People do believe that it is not an appropriate change at this time. We would ask that the court does not allow the defendant to return home. I know the court's aware, but for the record, there was a prior incident in October of 2025 involving the defendant and a teacher at the school being on the school property while children, I understand, were playing outside, involving a potential threat. That did not result in any charges.
Court does call the case of the People versus Calfoon.
Good afternoon, Your Honor. Ashley Feltus for the People.
Morning or good afternoon, Your Honor. It's definitely not morning anymore. Sunitha Dasmani on behalf of Mr. Calfoon. Would you like to take the podium, Judge?
No, actually, we can hear you wherever you're coming.
Okay, thank you.
All right.
Your Honor, we have several issues to address today. First, the court is would be, I think, the competency. That's okay.
Yes.
The judge may just indicate Mr. Calfoon is on live stream for the record.
Yes. And Mr. Calfoon, can you state your name for the record, please?
Jules Calfoon.
Thank you. All right.
Your Honor, the people are in receipt of an independent evaluation as to defendant's competency, the opines and competency in trial. The people would stipulate to that. I think the defense filed a motion for reconsideration as to the competency findings. So the court is going to reconsider its finding and the original date and make a new finding. We would have no objection to that.
Anything?
Thank you, Your Honor. We would agree to stipulate to that report and ask the court to find him competent going forward.
All right. I think the technical way to do this is the defendant's motion for reconsideration of the competency evaluation or competency finding the defendant incompetent. The court will grant that motion. I have reviewed the independent competency report, find it persuasive. Counsel has waived a hearing with testimony on that case, and both parties have stipulated to that report. Therefore, the court would then find that the defendant is competent to stand trial.
Thank you.
All right. Counsel, I would need you to make sure to prepare a competency order for me.
I'm sorry, Judge.
Prepare a competency order
Absolutely.
and submit it to the court for my signature.
Get that done, Judge.
And if also, I guess as part of that, I need an order that your motion to reconsider is granted.
Got it,
So
Judge.
those two things.
Thank you, Your Honor.
Next.
Your Honor, the court did give us a chambers conference earlier today, and we had a very productive conversation as to the issue of bond. When we were here last week, we discussed the defendant going for walks and the people's stipulation to the same, the defendant going for walks, and we were sort of discussed some of the ways to solve that. The court, the people, and defense were contemplating no go-to zones, places the defendant would not be allowed to go. It's my understanding, and I'll let defense counsel speak for herself in just a moment, that that's just not practicable for community corrections. So instead, defense counsel and I were exchanging emails about locations he could go, and I'll let her make her record for that.
No, that's right, Your Honor. When I spoke to the supervisor, tether agent, he indicated that it would be very difficult to have every single school and daycare excluded. But however, we could try to narrow it down by having specified and designated places where my client could go and exercise. They have access to a car, so they can drive to locations like the R, like the botanical gardens, Judge. And that's what we're trying to do now. And I understand from our conference that the court, that we outlined the different kinds of tethers, and I'll let the court make that decision, but that would be very helpful, Judge. And of course, keeping the gym as the option in the previous order, and I can draft a new order based on the court's ruling on it.
Anything else? No?
There were 7 locations that defense counsel and I discussed via email. I'll start with the ones that people have no opposition to.
All right.
The botanical gardens, Trinkley Marsh at Easton Farms Preserve off of Dancer Road, Nichols Arboretum, the Ingalls Mall location near Burton Tower and the Michigan League, and the Broadway Bridge near the Huron River. There were 2 locations that were requested by defendant that people are not agreeing to and would object to. The first would be the Ben and Jerry's ice cream
store on State Street and the Natural History Museum at the University of Michigan. The concern of the people with those two locations, especially the Natural History Museum, is the presence of children during the summer months, especially doing school trips and also during the school year doing sort of field trips, and the large amount of children that can be at those locations. So we would not agree to those two locations, but would stipulate to the remaining 5 that we've indicated.
And one of the questions the court had prior to hearing counsel is, and my understanding is that the alleged activity, were they specifically directed at children?
No, Your Honor. The note specifically left said people, did not say children, but the concern of the people remains that the defendant was engaged in in the underlying case at an elementary school, which of course is a location that does contain a large number of children. So that is the concern of the people with those two locations specifically.
Understood. All right. Yes.
Nothing to add, Your Honor.
All right. What I will do is the locations that the people don't object to, I certainly will allow those locations. I would agree with the people regarding the museum and will not allow that. The difficulty, not because I like Ben and Jerry's ice cream, but the difficulty for the Ben and Jerry's ice cream is certainly there may be kids there, but I don't see it as that type of gathering place, particularly down on campus. That you're right, that the Natural History Museum might entail. But at least for the time being, I'm not going to allow that particular location. Okay, so
Thank you, Your Honor. I'll get-
the ones that the people agree to, I will allow.
Thank you, Your Honor. The next,
Just so that we're clear, it's still a home confinement tether with the ability to go to those locations.
okay, thank you, Your Honor. I wanted to raise another issue, Judge, that is related to his bond conditions.
Yes.
I wanted to move that this court allow him to return to his home address on Duncan Street. The school is now out of session, Your Honor, and I understand the proximity to the elementary school. And I understand that, but he has been for the past 6 months in compliance with all of the court's conditions. He has been confined and unable to even go out, and he has had a very difficult time with that, Your Honor, and still has complied with all of the court's conditions. I am asking this court to consider him moving back home. Thank you.
Yeah, for the record, the people are opposed to that change in bond. The people do believe that it is not an appropriate change at this time. We would ask that the court does not allow the defendant to return home. I know the court's aware, but for the record, there was a prior incident in October of 2025 involving the defendant and a teacher at the school being on the school property while children, I understand, were playing outside, involving a potential threat. That did not result in any charges. But then we do have this extra incident that happens that does result in charges in January of 2026, where the defendant was remaining at his house at that time. He had lived in the house for both of those incidences, and we are opposed to any change in bond. I've had the opportunity this afternoon in court to speak with a teacher who works at Hazley Elementary School, and she's assured me that she feels confident in speaking for the teachers at that location, and they would also oppose any change in bond to allow him to go back to the home, as well as I've had the opportunity to speak with a parent of a Hazley Elementary School child, and she's informed me that she feels confident that she could speak for the parents, and the parents of these children would also oppose the change to allow him to go back home. I understand that there are concerns about, and I know school is out right now, and so I want to share with the court what I understand the concerns to be. That there's concerns with feeling safe sending children to the school by the parents, given the nature of the threats. Concerns that the children would not be safe if he was at his home because of the proximity, should he choose to leave, if the police response couldn't be done in a sufficient amount of time, because he's so very, very close. And I understand the concern from the teachers, a similar concern. Also, the teacher that I spoke with expressed to me a concern she had about her ability and the children's ability to remain focused on their schoolwork and to remain focused on what they're doing due to the nature of this incident. She shared with me that previously, after the incident happened in January until the end of the school year, it was distracting and it was disruptive when anybody would walk outside the school in the outside area, and had a lot of concern and fear around him being so very close to this school. If the court is
But
inclined,
is that related to this particular individual or any individual walking to the school?
which part, Your Honor?
The people walking outside the school. I mean, I'm very familiar with Hazley, and so that if you just come off of Duncan, you can walk up that, I think it would be whatever side of that building, the south side of that building, along the walkway, as long as like you were headed toward Hazley Woods or something along those lines. So
I should clarify. My understanding was after this happened in January with the defendant and the note on the window, other people walking outside created a lot of concern and distraction because of this, because of the fear around this incident.
okay.
If the court does intend to make a change to the bond to allow the defendant to return to the home off of Duncan, the people would respectfully request a delay in that happening, not having it happen today, not having it happen for a couple of days, but to allow some sufficient time to get information out about safety planning, any tether parameters that would be applicable, and anything else to allow information to spread to everybody in a calm and rational way that'll allow everyone to feel safe and clear on what any condition might be. Thank you, Your Honor.
And just so that I'm also clear, we had discussed in the bench conference that the staff returns on the 10th of August.
That is my understanding.
All right. And also, I'm a bit, well, I'm not unclear, but the prior incident that you're talking about was an incident where the defendant was on a bicycle traversing in the area of Hazley School.
I believe on school property. Yes, Your Honor. And there were children playing outside, is my understanding from the conversation I had today.
And the stopping now, and I'll try to be as clear as I can about this. We're dealing with somebody who suffers from autism to a certain degree, and then with some other issues. And my understanding is in that incident that the defendant was stopped by the individual while traversing through Hazley School. I
understand that they had an interaction. I'm not completely clear on how it came about, but I understand those two individuals did have an interaction. Yes, Your Honor.
Okay. So I thought it was a circumstance where he was told not to be there, or I guess what I'm trying to figure out is he had not previous to that point in time been trespassed.
Correct.
He had not.
Talking about the October date, Your Honor. Yes.
Yeah.
Oh, very good. Thank you.
And also, I guess, put it this way, was there authority to deny him access to the property?
I can check really quickly, Your Honor, but I'll correct this if it's incorrect. My understanding was he was on the school property when the children were outside. So the teacher confronted him or had an interaction with him to tell him that wasn't appropriate. But if I could just have 1 second.
I can represent to the court that he was not he is 18 years old and does not go to Hazley Elementary School. And so he, while school was in session, did not have the authority to be cutting through on that path when he was stopped by it.
Well, I'll wait for the answer.
Sure.
Nothing to worry about.
Thank you, Your Honor.
Hmm.
May I have the court's question one more time? I want to make sure I get it.
Well, was presumably that the interaction occurred because he didn't have authority to be there.
Yes, that's correct, Your Honor. I understand there's signage that indicates that the school grounds are closed during the school day. And when he came down the path on the school day, a teacher confronted him and said, "Hey, you can't be here." And that's when there was the statement about the gun. And subsequent to that, a detective did trespass him. An Ann Arbor police detective, is my understanding, trespassed him from being able to go back to Hazley.
Okay. So there's signage.
And I haven't seen the signage, Your Honor. I'm
No, I understand, and I guess I would be curious, and I just aren't aware of the authority for the signage. I can put up a sign saying anything,
Yes,
but
I'm not.
whether or not there's some authority for that.
I would have to check, but
Okay.
it would make logical sense to the people that Ann Arbor public schools could close their campuses during the school day for people that aren't students or parents or teachers to have access without prior authority or going through a visitor process. When I visited elementary schools, I've had to go through a visitor process.
Right, and I get the building.
Yes.
Certainly, I understand the building. The question I have is to what extent that extends to the grounds.
Very good.
Because I can think of a few schools where that almost becomes an impossibility. Because they're neighborhood schools. And if one, I guess from there, if one wanted to traverse, say, to Maple Road, certainly you go up to Miller and then go down. But depending on where you were going, you might just go straight through and through the path or the entrance that goes toward Hazley Woods and then out and then up to Miller.
And I apologize for not having a good answer on that right now for you, Your Honor. I can get an answer about the authority for the signage and all of that. It's not something I have in this moment, but I'm happy to work on that.
And just one more question regarding an incident, that the interaction occurs without the intervention of the police. Is that right?
The initial October interaction. At the time, yes, the interaction occurs. And I think police contact happens later. I don't think it happens in the moment.
All right.
Anything else?
No.
Thank you, Your Honor.
I may offer two things. One would be just as a counterpoint to what's been presented to you. I have many letters from neighbors that have known Mr. Calfoon for his growing up. And many of them expressed that they did not, they were very comfortable with Mr. Calfoon returning back to the neighborhood. I have several letters. I could provide them to the court. They're just in electronic form right now, but I could get those to the court if the court is interested in seeing them. And second, Judge, I understand the teachers' concerns about the school. The house itself, the back of the house and the sort of garage structure abuts the property of the school. But if the court would allow, we could fashion very restrictive conditions so that even, he has to exit from the front of the house and turn to the right to avoid the school. We could have exclusion zones set from his back porch of that house up to the property line and through the, school's property. I'm just trying to find a solution here, Judge, that would allow him to be at his home, which I believe would be very important for his mental health, for us proceeding on this case. He has again complied with 6 months of the court's very serious restrictions and done it successfully.
And Your Honor, I wanted to correct one thing to make sure. The interaction between the defendant and the teacher didn't involve the police, but the police were contacted that day. I wanted to make sure that that was clear for the court.
Yeah, I thought you had answered the court's question that
How much?
they see this individual. There is a teacher who interacts with the defendant,
Yes.
and then the police are called later.
Yes, not like a long time, but that same day they are contacted. I think very shortly thereafter. Right, as the teacher went inside.
So the police report if the court wanted to.
It happens the same day, very shortly.
And do we have the date of that interaction?
October the 6th.
October 6th. So somebody could get to the court, I don't know whether, well, the officer, I would suspect would have, if he were trespassed, read a report or written even a simple report or a citizen interaction. Pardon?
We have a report.
Oh, you have?
Yes,
Okay.
it was supposed to discovery.
Okay, very good. And then he was trespassed, and then without further incident, theoretically off of that
Until January.
until January.
Yes, Your Honor.
All right. From the south side of the Duncan entrance to Hazley, Mr. Calfoon's home is 3 houses down. Is that right?
I have a map if the court wanted to see it, but it is, I can tell you, spot here.
It's two.
Like I have one of those line drawing maps,
Mhm.
Judge.
So but it certainly isn't that first house. Right.
I can show you right. I'm just gonna. Yeah.
It's the second house, Your Honor.
Second one.
And
That's what I thought it was too.
The back of the home, Judge, the rear of the home is approximately 100 feet from the school property.
Say that again.
From what I understand, the back of the home is about 100 feet from the school's property line.
So to the fence.
Yes, correct. And then another approximately 45 feet from the school building. I think those markers are they indicated there, Judge? If not, I have it on a second piece of paper.
No, that's okay.
And this is rudimentary Googling and.
No, I understand. So approximately 150 feet from the back of the house, it's 150 feet to the building.
That's right.
First, the satellite image. I'm getting about closer to maybe 100, or not 100, I'm not sure. It's a longer backyard than it is a wider backyard. And a longer lot.
Yeah, I'm trying to
I have a
picture which one it is in my head, but I think I know which yard it is that abuts the,
May I approach?
yes.
Just have it pulled up for you.
Yeah. So
Where
The 901 address
is,
is.
that's it,
Mhm,
that's cool.
mhm.
Got it. I see which. I got it. Okay,
Thank you.
thank you. Okay, anything else on this issue?
Nothing further. Well, thank you, Your Honor. Thank you.
All right. Um, part of the court's quandary in terms of dealing with this would be that it would be easy to just exclude the individual, but then excluding the individual for ever is not really what's going to happen. So the safety on one hand is certainly, or potential threat is one thing. On the other side of that are certain things that are unique to this particular defendant. I also then have competing views of the defendant in that those, and it doesn't surprise me necessarily, that those in the neighborhood that know the defendant don't have a fear of him and have, to a certain extent, a relationship with the defendant. What I am inclined to do at this point in time is, because and also there is the other issue that my understanding is that there are now 3 people in the studio apartment, no air. They're there. Some of that's going to be resolved with the lifting of certain restrictions for the defendant, not only for his physical health, but certainly for his mental health and for his condition, that he be allowed out and able to exercise. Having said all that and realizing when the teachers returned, I'm going to do, in effect, what is an interim order that will last for a period in time, and then the court will hear additional argument and then review it. Acceding in part to the, well, what I'm going to do is I'm going to permit temporarily the defendant to return to his home. In returning to the home, he is already prohibited from any property, basic school property. This is going to change a couple of things are going to change. Yeah, one thing that will change is the GPS, the order that for community corrections, the home confinement order. In returning to the home, he will not have free reign. It will still be a home confinement tether, allowing him to go out. I would take the defense counsel's suggestion that he is only able to enter the home and then to leave the home through the front of the premises. And then from the front of the premises, he must make a right out of the front of the premises. What that does is that prevents the defendant from passing by the entrance to basic school. My understanding, and can't remember necessarily, but it was relatively recently, the last time that I was there, the enclosure, other than the entrances from the neighborhoods there, that the property of basic school is fenced to at least on that side. There are fences to the backyard marked. So will operate along that. I know there are fences on 3 sides of it. So I'm going to allow him home. That will only, we have a hearing, or did have a hearing. I'm going to set a hearing for October 6th, which will be
August 6th, Judge?
August, what did I say?
October, sir.
Did I? It's been a long day.
Okay.
Yes, August 6th. For review of that order and compliance, I will hear additional arguments from either side as to whether or not it would work. And then to also revisit it with the understanding that the school year begins, and then taking all of those concerns in light of that. So that's a long way of saying that while I'm allowing it or permitting it to occur, it may be that the court's decision come August 6th is that it would revert back to something like we have right now. I would also, and understanding the people's desire to be able to communicate effectively with those that are involved and may be affected, this order won't take place, or the ability to return will not happen until the 13th Monday, to allow communication to those that are involved. Anybody need clarification on what I've just ordered?
Your Honor, the house appears to sit facing east with the school
Yes,
behind it to the west, and entrance is south of the home. Did the court,
the entrance is south, correct?
did the court want me to indicate the defendant could only turn right, or did it mean to indicate he could only turn left to go north, away from the entrance?
I might have my directions mixed up. But anyway, he has to exit through the front away from the entrance to Hazelin.
I think that would be a left turn northwest, as opposed to a right turn south.
You may be right
Okay.
on that. Okay.
So I did have one question, Judge. It's just, would you like this to be the subject of a second order that's not combined with the order regarding bond conditions? So like there's the order regarding bond conditions regarding the walking, and then would you like a separate order for this sort of interim order allowing the defendant to reside at his residence?
That would be the request of the people, because we'll.
Yeah.
To the walls.
One, you won't
Got it.
stipulate to the other one. So
Got it.
have it a separate order. Also, though, because if I change it come August 6th, I have a separate order that would change back or be vacated.
Understood. Thank you. And then the very last thing is just to set another date.
Yes, and that will be August 6th, 2026 at, I'll set it at 9, but you'll get your time blocks on that. And I would just say this, that in a circumstance such as this, there's no one that is going to be pleased at all necessarily with any of the court's rulings. The court is operating on the information that it has. This court, in all the time I've been sitting on the bench, certainly would do nothing that I believe would place the community or anyone in jeopardy. But there are, as I've indicated, competing interests that the court is attempting to try to balance in fashioning that order, which is why I'm ruling the way that I am, but then also making sure that it will be reviewed and that there is the potential that it will change. All right. All right. Thank you, folks.
Yeah.
Thank you.
Mr. Calfoon, you're all set. I'll give you a call right after, okay?
All right.